Hi, Slow.
Hello. Okay. So I'll record it and post it on YouTube. The last lecture is up on YouTube, or it should be. I think I've sent you the message for that. I'll send you an invite to Friday's class just after this one's over. First thing is a bit of business, because we're writing, or you're writing a test next next class. So I've thought about this a bit, and so what I've come up with is this. Can you see that? Hello? Hello? Is anybody there? Oh, you can't see it. Okay. Okay, let me try that again. Let me share screen. And that's not coming up, I gather. Okay, I did send you the test study questions on your Moodle page, or I posted them on your Moodle page. So if you want to have a look at that, I don't seem to be able to share for some reason. It's just taking over the whole screen, but at any rate, I'll just talk about it for a second. So what I've decided is that you're going to write your test next Wednesday. You'll have the class period to write it, but you've actually got a little bit more time than that if you want it. So I'll email you the test at noon, and you'll have till 5 o'clock that evening, this next Wednesday, September 30th, to submit the test to me. So that means obviously it has to be typed, and you have to submit it and make sure your name's on it and so on and so forth. So that's what I've decided how to test you. There's two sections. In the first section, I'll give you a series of questions, and you'll have some choice here. I think I'll give you 2 or 3 short answer questions to respond to, and then you're going to have to answer one of the 3 questions that's on that page. I'll put 2 of those essays on the actual test, and you'll have to answer one of them. Okay. So, anyone have any questions about the test? No? Everyone's okay?
So I have a question.
Sorry.
Oh, sorry. Sukfer?
Yes. So like as you mentioned the 3 caution, so from these 3 caution, like we will get the short questions from like the topics.
Well,
Like we will get the
no,
topics?
no, not necessarily. The short questions will come from the material, any material that's covered in the class, and the material covered in this test is up to and including everything we covered until the last class. So today's material won't be on it. But it could be from anything that we've covered in the first 3 weeks.
Okay. But the essay question would be from these 3 questions.
Yes, I'm going to put 2 of those questions on exactly as you see them.
Okay.
And you're going to have to answer 1 of them.
Okay, thank you.
Okay. Kim, did you have one?
Yeah, for the essay, I'm guessing it's the standard 12-point font, Times New Roman, double-spaced.
Yes. Thank you for pointing that out. Right. Yes. You're right. Double-spaced, Times New Roman, or something similar, 12-point font. So that is what I'm looking for. Yes. Thank you.
Awesome. Thanks.
Anything else? As I've said before, you're free to work together. You can certainly work together over the next week, however you can get together safely to talk about what we've covered in the course. That's not just a normal thing for university students to do, but as my experience has been, it's where students learn a lot talking to each other outside of the class time. And you're certainly free to discuss the questions, the essay questions that you have and how you might answer them. That's all perfectly legitimate. What's not legitimate is 2 or more people handing in the exact same or pretty much the same essay because you prepared it together. And so as long as you understand that, that you can't do that, getting together is perfectly fine. Does anyone have questions about that? Okay. Oh, let me. Okay, now let's see if I can share my screen. People can't see that, I'm assuming, can they? What am I doing wrong? Okay, share. Let's do this then. That's what I was doing wrong. Okay, there we go. So people can see that now, I'm assuming.
Yes.
Okay, so I just wanted to quickly, not that quickly, go over the Canadian Charter of Rights and Freedoms, or some elements of that before proceeding to the 2 cases. I think I forgot to tell you exactly what I wanted you to read today, but there are the 2 cases that are next on the outline, the Oakes case and the Catter case. And so, but before that, just a little bit about the Canadian Charter of Rights and Freedoms, which we talked a little bit about before. The Canadian Charter is part of the Constitution. The whole Constitution is developed from an act in 1982, and before that time, Canada's did not have its own constitution. It was covered under the British government and the British North America Act. So in that act, ultimately the British Parliament had control over fundamental changes to the to the situation in Canada. And so Pierre Elliott Trudeau, the current Prime Minister's father, was quite adamant that Canada should have its own constitution. It should be patriated or repatriated. It should exist in Canada and be under the control of the Canadian government. So he managed to do that in 1982. So the Constitution as a whole and the first 33 articles in the Constitution constitute the Canadian Charter of Rights and Freedoms. So as you can imagine, there was a political battle to get this Constitution through and to get the Charter of Rights and Freedoms through. So I think you could see this right from the very beginning in the preamble, which is that first sentence quoted there, whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. There's nothing controversial about the rule of law in that. So if it said, whereas Canada is founded upon principles that recognize the rule of law, that would be a completely uncontroversial, well, not necessarily. I was going to say uncontroversial preamble, but it would not have been uncontroversial for those Canadians who are Christian, and I suppose Jewish as well. But I think the main concern, since the vast majority of Canadians, particularly at that time, would have been Christian. And the majority of people still are either agnostic or atheist or Christian. So the supremacy of God being in there is a little odd, given that it may be inconsistent with Article 2A, which gives us freedom of conscience and religion. So can you have a country founded on the supremacy of God and yet tell everybody that they have freedom of conscience and religion? As far as I know, that inclusion of the phrase supremacy of God has not entered into any constitutional or charter cases. Certainly the rule of law has entered into a number of cases, charter cases. So including the supremacy of God there it is maybe not as controversial as it might first seem. And maybe that's because it's part of the preamble, but the rule of law is in the preamble too, and it's been quite influential. And there was a case, it's in your text, but I never assigned it, but it's the Manitoba language rights case. And that case dealt with the fact that in the new charter, there is the requirement that laws be written in both English and in French, the two official languages of the nation. And somebody in Manitoba brought forward a case that suggested that all laws between 1890 and 1982 were rendered null and void because they were only written in English. There were, in the early days of Manitoba, up to 1890, there were some laws written in French, but since 1890, they were written in English only. And that seemed to violate the Charter of Rights and Freedoms. So should they all be rendered null and void? In response to that, the Supreme Court said, no, they're not all rendered null and void. It was, in one way, there's the easy solution to this is to have all of the laws in Manitoba translated into French as well as to English. And in the future, publish all the laws in both English and in French. So that's not controversial. The controversial part is what do you do in the time it takes you to translate all of those laws? Do you go back to a state of nature, so to speak? And the court decided, no, that doesn't make sense because it violates the rule of law. So interestingly, the Supreme Court said that this notion of the rule of law both demands that the laws, there's a problem with the laws being written only in English, and that something has to be done to correct that, to translate all of those laws into French as well, and future laws be made in French and English. But it also says that to do that and be left with no what they call positive law would be also inconsistent with the notion of a rule of law. So that's what that case was all about. So the rule of law is an important concept, and I'll just read something to you from the Manitoba case, if I can find it here. Okay, so in the present case, he says, the rule of law is a fundamental principle of our Constitution, and it must mean at least two things. This is, well, I've got an old copy of the text. My new one hasn't come in, so it's on 34 of my text, but I don't know which is the 4th edition. You've got the 5th edition, so I'm not sure what page it is in yours. But the rule of law, a fundamental principle of our Constitution must mean at least two things. First, that the law is supreme over officials of the government as well as private individual, and therefore preclusive of the influence of arbitrary power. So the Constitution, the law rules. I mean, the rule of law means, as you would expect, that the law is the rule, not the government of the day or some arbitrary individuals. It's the law that governs us. Indeed, it goes on, the judgment goes on to say, it is because of the supremacy of law over the government as established in Section 23 of the Manitoba Act 1870 and Section 52 of the Constitution Act 1982 that the court must find the unconstitutional laws to be invalid and of no force and effect. Second, the rule of law requires the creation and maintenance of an actual order of positive law which preserves and embodies the more general principle of normative order. So the laws are rendered null and void in a sense, but that does not mean that we return to a state of nature. They're presumed to hold until such time as the problem can be corrected. Otherwise, we would violate this notion of a rule of law. Okay, so.
Can I ask a quick question?
Yes, sure.
So I accidentally read that one as well, the Manitoba case, and how did that even happen? I would think it'd be pretty, it's pretty black and white, make laws in both French and English. It seems such a long time for that to just kind of get swept under the rug.
Well, but because it wasn't the law. Prime Minister Pierre Elliott Trudeau made Canada officially bilingual. It wasn't officially bilingual until that time. New Brunswick was officially bilingual, but the country as a whole was not. So, see, I can remember when that was a controversial act in the 1980s and 1970s when Trudeau started an official bilingualism. I remember, the shock of seeing like a cereal box with English on one side and French on the other. I mean, we're all used to that now, but that wasn't the case before. So that's why the law went, that's why so many provincial laws were written only in English for so long, because it was perfectly consistent with the law. It only became inconsistent once the charter came into effect. Does that answer your question?
For sure. I think I must have, I missed the fact
No,
that had happened after.
Yeah, I guess that's just kind of background knowledge that you're too young to remember. Assuming you were born after 1982. Yeah, so so the first article in the charter has been one that's been had to be interpreted in a number of cases, including the cases that we're going to look at today, particularly the Oakes case that we're going to cover just after we discuss this Charter of Rights and Freedoms. And just to read it, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So the idea here is to say, okay, the Charter of Rights and Freedoms sets out rights of individuals, but they're not absolute. They must be balanced between the interests of society and the first article tries to lay out that, although in fairly vague language that must be interpreted. So what's a reasonable limit? What's the difference between a reasonable limit on our rights and freedoms and an unreasonable one? What can we demonstrably justify as a reasonable limit? And what does it mean to be a free and democratic society? So all of those, the notion of limits, the notion of justification, and the notion of a free and democratic society, all had to be worked out by the courts after the charter was brought into effect. And this was not a surprise to anybody. You can't possibly make up a charter or a constitution that's going to determinatively settle every case brought before it. So everyone knew at the time that there was going to be lots of charter cases and trying to figure out this stuff. And the idea under common law is that once the Supreme Court, especially, decides on a case, you've got a precedent for future cases. So the Oakes case that we'll talk about today set the precedent for how we determine a lot of these questions that are set out in this first article of the Charter of Rights and Freedoms, particularly with respect to reasonable limits and demonstrably justified. So I won't go into that more because we're going to discuss it later today. There's a bunch of fundamental freedoms that are covered in Articles 2, 3, 4, 5. No, those are more democratic rights. Sorry. So in the second article, Article 2, really covers the fundamental freedoms that we have. And they're listed in there. So 2A says freedom of conscience and religion. This can bring up conflicts between religious beliefs in certain groups. For example, LGBTQ plus groups and whether or not homosexuals are listed as an identifiable group that's saved from discrimination as determined in a later article, Article 7. Whether same-sex marriage is allowable, even though it conflicts with the religious beliefs of most mainstream Christian religion, certainly the Catholic Church, and a lot of the Protestant churches as well. So that would have to be worked out in future court cases. We'll look at some of those in this course. 2B gives us freedom of thought, belief, opinion, expression, including freedom of the press and other media of communication. Now, clearly, this can create all kinds of questions about how we can have freedom of speech, for example, or freedom of expression, as is referred to in the Canadian Constitution and Charter, how we can have freedom of expression and yet limit it so that certain kinds of speech are deemed to be an expression, are deemed to be not allowed. In particular, hate speech. In Canada, we do have, it's been determined by the court that hate speech is not going to be however that's defined, is not going to constitute a legitimate freedom of expression. So it's one of those things that under that first article, we can demonstrably justify a limit on freedom of expression that's consistent with a free and democratic society that prohibits hate speech. Pornography has been the subject of a number of Supreme Court and charter challenges to determine what kinds of sexually explicit material fall under the freedoms granted in 2B of the charter, and what kinds of pornography are okay. Again, we're going to discuss a number of cases dealing with pornography. I think we start looking at cases of freedom of expression next week. Next class, this Friday. Freedom of peaceful assembly and freedom of association given in Article 2, Section C and D. Both of these rights are essential for groups. If you think of freedom of association, for example, a union or a social activist group or something like a book club or a sports club, they must be able to get together and express their opinions, or else they're not really doing the job that we require them to be. And those two fundamental freedoms are covered in Section 2 or Article 2 of the Charter. Once again, this is open to some difficult interpretation, because though we've got freedom of association, can we distinguish that legitimate freedom of association from the association that someone might have with a terrorist group? Or can the freedom of peaceful assembly get limited at all when there's disruption caused in public spaces by your assembly, and maybe it not being as peaceful as might be? We're seeing that in the States now with all the Black Lives Matter protests. Some of them clearly are, most of them and most of the protesters are clearly, they don't have this particular clause in theirs, but they've got something similar in the American Constitution. Most of them are clearly matters of peaceful assembly and should be considered legitimate. Others where rioting occurs, where buildings are broken into or burned, or when people attack other people, that's not peaceful assembly, and so is not a legitimate expression of a fundamental right and freedom. Where you draw the line between the two is always the tricky part. The devil's in the details, as they say. Section 3 to 5 discuss democratic rights. Section 6 discusses mobility rights. That's kind of interesting in terms of the current pandemic and the Atlantic bubble, as it's called. You can't come into, for a while, the borders in Atlantic Canada were closed to people outside of Atlantic Canada. Now it's open, but you've got to, you've got restrictions on your travel and what you must do when you get here. Namely, you've got to self-isolate for 14 days that you don't have to do in other provinces. And so that hasn't come before as a charter challenge, but I think you could see that come as a charter challenge if this pandemic extends longer than we think it's going to extend, and certainly longer than we hope it's going to extend. Section 7 to 14 discuss our legal rights. They cover everything from legitimate searches, freedom from arbitrary detention, and so on, including cruel and unusual punishment. There's legal rights in Section 7, and this Section 7, everyone has a right to life, liberty, and security of person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice, has proven to be a incredibly important and much debated article in the courts. Just to give you some sense of it, the right to an abortion that is now in Canada, or the complete decriminalization of it, comes from a challenge to the courts a number of years ago on the basis of security of person. and the right not to be deprived thereof. That is, that a woman, as the courts decided, Supreme Court decided eventually, ending her pregnancy, not allowing a woman to do that is an infringement on her liberty and security of person. The new act in Canada about medically assisted death comes out of a similar kind of charter challenge about that involved euthanasia or physician-assisted suicide, or as it's called now, medically assisted death. That not being able to determine the time of your death and to get help during that time was considered to be an infringement on liberty and security of person. We'll have a look at some of those cases as well, both in abortion and medically assisted death. Equality rights are an important part of our Charter of Rights and Freedoms. And so as it says in this article, every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical ability. Having said that, the Charter goes on to say that subsection that I just read does not preclude any law, program, or activity that has its subject the amelioration of conditions of disadvantaged individuals or group. So you're not allowed to discriminate on the basis of those things, race, religion, sex, and so on, unless it's in a program that's meant to ameliorate the condition of those disadvantaged individuals or groups. So that's been a heated debate over the years, continues to, I think, bubble underneath some discontent from some, I guess, primarily white folks and white men in particular, who feel like they've been unfairly discriminated against by laws that, as the bottom bullet says, that aim to ameliorate the condition of disadvantaged individuals. There's a whole lot of discussion we can have and will have on that issue. It once again is raising its head in an ugly manner, particularly in the United States right now, but which is seeping over into other populist governments in the world right now, where there's I don't think it's too unfair to say, a lot of angry white men in particular who are seem to be fed up with what they see as an unfairness in the system. I don't actually think that's true, but certainly a lot of people do think it's true. Interestingly, when you look in the first bullet in the subject of illegal discrimination, race, national or ethnic origin, and so on, you'll notice that sexual orientation is not one of those groups. That list, however, is not meant to be exhaustive or exclusive. So in later cases, sexual orientation happens to have the same strength as any of those groups listed in that article in subsection. This is one I think Kimma was brought up earlier about official languages and so on. Just to conclude this brief kind of overview of the Charter of Rights and Freedoms is section 33, which is a very curious clause. The notwithstanding clause, the meaning of notwithstanding means in spite of the fact that, or regardless, So, for example, notwithstanding the evidence or regardless of the evidence, the consensus is that the jury will not reach a verdict. That would mean that despite there being all kinds of evidence to show guilt or innocence, whatever the case might be, the jury's not going to reach a verdict. The law has been used to, as I say, put too simply, say essentially that despite the fact that the law, some government has just passed, a provincial government has just passed, despite the fact that it violates a section of the charter, you can do it anyway. This came out of, again, a lot of debate at the time in concerns that various provincial governments had. The Quebec government in particular was concerned about some of the language rights that both English and French were had equal place in under the law. Quebec wanted to and went through a stage in which they wanted only French used and only French signs put in place and so on and so forth. So they've actually invoked the notwithstanding clause on numerous occasions with respect to Section 20. The notwithstanding clause cannot be invoked for all of the Charter of Rights and Freedoms and none of the rest of the Constitution, but it can be with respect to 20 in sections 7 to 15. So again, it's an odd and particularly Canadian solution, for better or for worse, that is in our Constitution that allows violation of the charter, certain sections of the Charter of Rights and Freedoms, if a democratic body, such as legislature, provincial legislature, says so. One of the last controversial cases in which the notwithstanding clause was used is the current premier of Ontario, Premier Ford, when he invoked this change in to the makeup and number of the ridings in the last Toronto mayoralty election. But at any rate, that's my overview of the Charter of Rights, Canadian Charter of Rights and Freedoms. Does anyone have any questions or comments to make? Okay, so I'm going to stop sharing that. And now I'm going to oh, no.
Hello, sir. I just wanted to apologize for joining late because I misunderstood about the class.
Yes.
So that's all, everything. I just wanted to apologize about that.
I'm sorry, I've got to get my dog out of my room because he's camping and I can't hear what you're saying. Come on, Cassie. Come on. Yeah. Okay, sorry. Can you repeat that?
I just said I wanted to apologize for joining late for the class.
Oh, okay, okay, sure. Yeah, no problem. Yeah, it is being recorded, so you can get it. Sorry, once again, this is part of the trouble. Some people have problems working at home because of young children, because of old dogs. Hang on one sec. Come on. Okay, sorry about that. So let's um, uh, no, I don't know what I'm doing. Hmm. Okay. There. I don't know why I had trouble doing that today. Okay, so move on to talk about the Oaks case. And this is probably as far as we'll get today. So we'll probably start on Friday with um, the Cater case. So if you haven't read that, make sure you read that, and then go on to look at the first couple of cases covered under the next topic on your on the Moodle page. So this case has to do with, let me see if I can get this a little smaller. No. No. Okay. Sorry. Okay. So the Oaks case has to do with that Article 1 of the Canadian Charter of Rights and Freedoms, the one that guarantees the rights and freedoms set out, subject only to such reasonable limits prescribed by laws can be demonstrably justified in a free and democratic society. So it had to do with whether a particular law, which clearly violated the Canadian Charter of Rights and Freedoms, whether that violation was legitimate because it was a reasonable limit of that law and could be demonstrably justified in a free and democratic society. As it turns out, the law in question here, the Supreme Court deemed that it was not it was not a reasonable limit prescribed by laws can be demonstrably justified in a free and democratic society. So what was the case?
Sorry to
Well, there was
interrupt.
a man, Mr. Oaks, and he was arrested in London, Ontario in 1981. At the time, he had $150 worth of hash oil on him, and he also had about $620 on him. He was charged with possession of a narcotic with the intention of trafficking. Now, it's the trafficking portion of the law that was at issue here, because Section 8 of the Narcotics Control Act in Ontario at the time said the government had a right to presume the intention to traffic no matter how much narcotic you had on you. So the smallest amount, anything that would lead you could be charged and convicted of possession of narcotic, also meant that you could be charged with intention to traffic. So even very small amounts of it. And the government said that it wasn't as if you couldn't escape that charge of possession or intention to traffic, although possession was, I guess, fairly straightforward. If you've got an illegal substance in your pocket, it's kind of hard to successfully fight that you don't have it in your possession. But whether or not you have the intention to traffic is, more up for debate. So, the Section 8 of the Narcotics Control Act didn't say you couldn't you couldn't successfully fight the part about the presumption of the intention to traffic. It just meant that you had to prove your innocence. Instead of the state typically has the duty or the obligation to prove guilt, whereas the person charged is presumed innocent until proven guilty. Here, once you have been charged with possession, you're also assumed to have the intention to traffic. In that part of the law, the intention to traffic, you have to prove that you didn't have an intention to traffic. So it's what they call a reverse onus, where what's typically the onus of the state to prove guilt is now reversed, where the charged person has the onus to prove their innocence. In this, as Oakes argued quite obviously, that it violated his Article 11, subsection D of the Charter of Rights and Freedoms, and could not be justified under Section 1. Remember, Section 1 is the article that says all these things that we're going to set out in the Charter of Rights and Freedoms, every citizen has a right to those, except if the government can show that the restriction on those rights and freedoms is a reasonable limit prescribed by laws, can be demonstrably justified by a free and democratic society. So what is 11D? Well, it's pretty darn straightforward. Any person charged with an offense has the right to be presumed innocent according to a fair and public hearing by independent and fair tribunal. So this Section 8 of the Narcotics Control Act is in clear violation of Section 11D of the Charter of Rights and Freedoms. Now, the court also went on to find that it infracted Section 7, the one we talked about earlier, the right to life, liberty, and security of person, the right not to be deprived thereof, except in accordance with the principles of fundamental justice. So, but that doesn't in and of itself resolve the case, because the case is really about what's a reasonable limit to the rights that you have. So yes, you have the right, as the Charter makes perfectly clear, to be presumed innocent. It's whether or not this Narcotics Control Act law is a reasonable limit to your right to be presumed innocent. Is that a reasonable limit that can be demonstrably justified in a free and democratic society? So is what the issue at stake here, is that clear? Does anyone have any questions about that? It's a violation of his rights to be assumed innocent, and the government, the prosecution is going to claim, or did claim, that but it's a justifiable infringement upon rights given Article 1 of the Charter of Rights and Freedoms. Questions?
I just wanted to add something about in that.
Sure.
So after this case, it came to be Oakes test, which is applied in many of the cases in Charter of Rights and Freedom.
Yes.
Where the Supreme Court said, first we have to see whether the law is pressing or substantial, that
Yes.
what is the purpose or object of the law. Then is the limit on that is proportional on the rights. Then after that, it was rationally connection to the rights. Then limit must be minimally impaired. And whether the benefit outweighs the negative impact.
You're
So-
way ahead of me. You're exactly right.
Yes.
That's what the Oakes test, which came out of this case, that's exactly what the Oakes case established as a precedent, the Oakes test. And as it turns out in this case, according to the Supreme Court, the Narcotics Control Act, or Section 8 of it, which presumes guilt for trafficking if you're caught in possession, they said it does not pass the Oakes test. So you cannot assume somebody's got an intention to traffic if they're in possession. It's simply by the fact that they're in possession. You have to prove, the government has to prove the intention to traffic. They can't assume it and expect the charged person to prove their innocence. Absolutely right. And that's what you just said is what we're going to go over right now. Any other questions?
No, sir.
Okay. So as we just said, but very briefly, that what the Oakes case does is set a test called the Oakes test for restricting freedom under Section 1 and it has to do with what's consistent with what can be demonstrably proved in a free and democratic society. A free and democratic society, for something to be consistent with something in a free and democratic society, the Oakes test says it has to have respect for the inherent dignity of the human person, and so on, as that phrase indicates. That wasn't so much in dispute here as other aspects were. It's really this, one other thing is, what's the standard of proof in order to show that you can demonstrably justify? There were basically two possibilities here. One is the beyond a reasonable doubt, which is a very high bar to set, and it's what's done in the in criminal laws. However, like if you get charged for murder or robbery or anything under the criminal law, you are proven innocent. You are assumed innocent and have to be proven guilty beyond a reasonable doubt. So even if it's an unlikely situation, as long as it's not an unreasonable doubt, as long as it's a reasonable doubt, even if you think that person's probably guilty of it, if you have a reasonable doubt, you must that standard of proof means that the person must be found not guilty. In civil cases, in ones where it's dispute between two parties, not a criminal case, the bar or the standard of proof is much lower. It's just the preponderance of probability. So it's more probable that the person is guilty than not guilty. And that's a much lower bar, as I hope you can see, than beyond a reasonable doubt. We're going to look at, I think, next class, the RV Big M Drug Mart case to see what is a reasonable a limit that's reasonable and demonstrably justified. That case has to do, by the way, with whether or not it used to be in Canada that most provinces had what was called the Lord's Day laws, which prohibited commercial enterprises on Sundays. So grocery stores, any shopping thing was closed. Almost everything was closed on Sunday in Canada before the Charter of Rights and Freedoms. And the case that really started to change things was this R versus RV Big M Drug Mart case, which showed that the Lord's Day laws were unconstitutional. And so now we have the situation where obviously there's no distinction in what's open or what can be open on Sunday versus any other day of the week. Anyway, we're going to talk about that next class, I believe. So that's the standard of proof. And now the other part of it is whether, first of all, the objective of, say, a law like the Narcotic Control Act, which presumes guilt for trafficking when you're caught with possession. If the objective of that law, which seeks a limit on your charter rights, is of sufficient importance to warrant overriding a constitutionally protected right or freedom. That's one aspect of the Oakes test. Is it important enough thing to override your constitutionally protected rights and freedoms? And secondly, is it proportional? And who pointed that out? The proportionality test, Jiva?
Yes.
Yes. Okay. Did I get your name right?
It's Sanchita.
What is it?
Sanchita.
Sanchita?
Yes, that's right.
Okay. I probably won't get it right the next time I say it, but I'll try. Sanchita.
That's okay. Yeah.
Anyway, so let's take that test and see whether or not the presumption of intent to traffic when you're caught with any amount of drug, whether it's both sufficiently important and proportional. The proportionality test, in turn, has three different requirements. So it says, first, that the measures adopted must be carefully designed to achieve the objective in question. They can't be arbitrary, they can't be unfair, they can't be irrational. In short, they have to be rationally connected to the objective, which, going back to the first requirement, has to be of sufficient importance to warrant overriding your rights and freedoms. Secondly, the means used in the law, for example, must be rationally connected to the objective in this first sense, and should impair as little as possible. So if we found out that, okay, the presumption of guilt for trafficking drugs is both an objective that's a sufficient warrant, and if it were carefully designed so as not to be arbitrary, unfair, or irrational, then you would next have to prove whether this, the way this law works, infringes upon your right or freedom as little as possible. Is there something you could do to achieve the same important objective in a way that's infringes less on your rights and freedoms. And finally, for the proportionality test, you have to see whether or not the proportionality between the effects of the measures, and again, this was pointed out, is the cost worth the benefit? And you have to weigh those two things against one another. So even if it's an important issue, it's not arbitrary or irrational. There's no other law that could infringe less on the rights. If it's still the case that in your analysis, it's just not worth it, that you give up too much to get too little, then it fails the proportionality test. So how does the Oakes test make out? Well, in terms of its objective, the court ruled that the case meets the objective of being of sufficient importance to warrant overriding a constitutionally protected right or freedom. Why is that? Well, this case was a while ago. I wonder if in today's estimation, it would be the same thing. Since we've legalized marijuana, I suspect that an objective of fighting the use of that drug would be considered now as of sufficient importance to warrant constitutionally infringing or overriding constitutionally protected rights or freedoms. I have no doubt that hard drugs would, although that might change in the future too. But I don't know if hash oil would. But anyway, at that time, the court said that narcotic drug use is a very serious problem in society. Addiction's a serious problem. So it's an important enough issue that the objective of dealing with that is important enough to legitimize constitutionally overriding constitutionally protected rights or freedoms. So it passes part 1 of the Oakes test. Does it pass?
I just have a comment to make here.
Yes, go ahead.
As you said that earlier, it was not intended that, yes, it was a possession or traffic. So maybe it won't be right now. Actually, the thing is, possession or trafficking would be the same with now as well, because this is the case of 1986. So at that time also, trafficking means done with the intention, but more quantity shown it's trafficking. Suppose we have something and we don't have intention to do that, but the quantity will say itself that yes, it's for trafficking, right?
Right.
But the possession is there is no intention, but the quality intends that it is for trafficking.
Right.
So possession and trafficking both are the same part now also, and it was earlier as well. The law won't change for possession and trafficking anytime, right? Whether this is the case of narcotic tax, because not narcotics in Canada, in Ontario, but it will say that yes, the benefit has always outweighed the negative impact.
Yeah, so that has to do more with, I guess, part 3 of the proportionality. Is that what you're saying, or that I'm emphasizing something other than what the law is emphasizing, whether it's the intention to traffic, whether or not hash oil now would be considered sufficiently important to the objective of limiting the trafficking of that substance would legitimate infringing your rights and freedoms.
Yes, I mentioned about the legitimacy for hash oil, that yes, it will possess in future also, and it is possessing right now also, that hash oil is still, if you are supplying it in more quantity, it will result in as trafficking.
Right.
So you will be, the
Yes.
person would
Okay.
be punished
Yeah,
under Section 8.
I've got you. I just wonder if they would ever think that it's a serious enough thing to warrant as an objective, not in terms of proportionality, but I think given the changes in attitude towards so-called soft drugs, whether or not you would even think that it passes the first test of the Oakes test. But anyway, that's purely hypothetical, so it doesn't really matter, except as a kind of thought experiment, and changes in attitude. But anyway, at the time the Oakes decision was reached, it was said that the objective of the Narcotics Control Act was good enough if it also passed the proportionality test. But the Oakes case goes on to say that it does not pass the proportionality test. In fact, it doesn't pass even the first test of proportionality. This is the one that says, first, the measures adopted must be carefully designed to achieve the objective in question. They must not be arbitrary, unfair, or based on rational considerations. The court decided that the assumption that any small amount of narcotics implies the desire to sell those narcotics is not a rational implication. So the reverse onus in the law is not rational, and they said, also lead to unfairness, so that the law is unconstitutional, even without getting to the second and third tests on proportionality outlined in the Oakes test. Is that, anyone have any questions or comments about that? It's just not a rational implication to make that if you have a very small amount of a controlled narcotic substance on you, you're guilty of possession. It's just not rational to make the jump from that to the conclusion that you have an intent to sell, and that you must therefore prove your innocence, that you didn't have an intent to sell. As in a number of these cases, the actual criminal act being investigated might not be nearly as important as the implications for the law beyond this particular case. So while it's important, you know, drug tests and so on and so forth, I mean, you know, some guy caught with a small amount of hash oil in him, it's, you know, whether he's guilty or not doesn't seem to be earth-shattering in and of itself. But because of the way it brought out something in the law, and more generally about what the first article of the Charter of Rights and Freedoms actually means, the Oakes case has importance way beyond the rather minor drug issue that was involved. So we ought not to just dismiss a case because, well, geez, that's not that important a case. It is an important case because of what it brings out in the interpretation of the Charter of Rights and Freedoms. Any questions or comments? Okay,
No.
if you have questions about the test, shoot me an email, and we can discuss it either you know, by typing back and forth or a phone call. But you should start working on your test sooner rather than later. Don't leave it to the end and just look at the question. I know a lot of people have made this mistake in the past. They look at the question and say, yes, I can answer that. Yeah, I'm going to be okay with that. And that because it's open book especially, and the test is, I guess, I should make that clear, is open book, because there's no, for one thing, there's no way to police whether it's open book or not. So I should have made that more clear. You can look at your text. You can look at your at the slides and your notes and so on when you're answering questions. So in fact, if this week you go through and you prepared an answer to 2 of those questions, you'd be safe with that, and you type them up before you ever get to the test, you know that if you prepare for 2 of them, that you're safe that one of those is going to be on the test, because 2 of the 3 are going to be on the test. Then that part of the exam won't take you any time at all. You've already done it. You can certainly do that before the test, given that it's a take-home, and you can work on just the first section of the test during that 5-hour period next Wednesday. It's not what I'm used to in testing, but these are the conditions we're in. So that's perfectly fine. Okay, I will see you all on Friday.
Excuse me,
Yes,
I just have a question.
this is Attender.
No, that's Sanchita.
Okay. Oh, okay. Yeah, go ahead.
I just wanted to say that ask that you mentioned in that paper that section 1 will contain a question you have to answer in 1 or 2 paragraphs.
Yes, for the first
So
section.
yes, so the first section will be the questions will be from the 3 of them, or you'll be asking from yourself.
No, I will give you, they may or may not be connected to questions asked in the second section. They'll be more specific. The questions I've asked in for the long essay portion of the exam are pretty broad. They ask you about a variety of things. Obviously, you can't answer any of those questions in 1 or 2 paragraphs. So they will be far more specific than that. They could be a part of one of the questions asked in the long essay, but not necessarily. But you will have some choice there. So I'll probably give you, say, 5 questions, and you've got to answer, I don't know, 2 or 3 of them, whatever I come up with.
Okay, thank you so much.
Okay. Okay. Good enough. Oh, I see Keegan S has added something interesting there. Each province has a limit of marijuana one person may have on them at a single time. Going over that is considered to be possession with intent to traffic. Oh, okay. Thank you for that. Okay, see everybody on Friday. Bye-bye.